Good morning, everyone. Good afternoon. Good early morning, depending on where you're joining us from. My name is Jean-Pierre Gauci. I'm the Arthur Watts Senior Research Fellow in Public International Law and Director of Teaching and Training at the British Institute of International and Comparative Law. I'm one of the co-conveners of this webinar series, together with Barry Sander, who you can see on the screen. I just wanted to start by saying a few words of thanks. First of all, to everyone for attending this morning and for attending the last sessions. Today is the fourth day, I believe, of webinars in this series, and we've had some excellent presentations, some excellent discussions over the past 3 full days of webinars. So each day includes 2 webinars, and we've had some really excellent discussions, and I'm sure this will continue today and then the final day in a few weeks' time. Just before we get this going, I just wanted to say a few words of thanks, first of all, to BICL, particularly the events team, for their management of the series, including the website, the marketing of the event, as well as Liam, who is sitting behind the BICL logo on your screens, and who makes sure that everything runs smoothly. The second group of people I wanted to thank is the organizing committee. So besides Barry and myself, we were supported by a massive group of people that were incredibly kind and generous with their time in giving us the support and kind of feedback on all the proposals and the peer review process of all the proposals that we received, in order to make sure that this series is as strong as it has been and is, and that's as strong as it could be. I also wanted to thank all those who submitted abstracts for this webinar series. Unfortunately, we were not able to accept all of them because of time constraints, trying to keep the series to a manageable number of webinars. Excellent ideas in those abstracts, and we were a bit gutted that we couldn't include all of them, but thank you very much to those who submitted. And obviously, thank you very much to those who were then selected and accepted to participate in the series. I also wanted to thank the chairs, both Ezekiel, who will be chaired this morning's session, but also all the chairs of the various sessions over the past weeks in this series. And finally, the audience, whether those attending today and those who have attended the last few days of the series. We just wanted to thank you all for your feedback and for your time and questions and comments, and for the discussion that all of those questions have generated, both during the webinars as well as after the webinars, both via social media and elsewhere. So I think that is all the thanks that I wanted to make. I did also want to cover a bit of logistics. So first things first, the webinar is being recorded and will be uploaded on the BICL website after the event. Second, if you have any questions, comments, disagreements, encouragements, etc., please do use the Q&A box, which you can find on your screen. This will be monitored by Ezekiel as well as by Barry and myself, and we will try to get to all the questions. We can't promise to have the time to get to all the questions, but we'll definitely try our best. And I promise that all the speakers will also be looking at those questions, and even the ones that we don't have the opportunity to discuss will inform their work as they move forward. There is a chat function. Please do not ask questions through the chat function, so that we keep it manageable and not drive Ezekiel and the rest of the speakers crazy. But the chat function will be used for any speakers, etc., who want to share links with you. So please do keep an eye on that. If there are any links that might be of interest, and etc., we will post those in the chat box. I think that's it in terms of logistics. So Barry, over to you.
Thank you, Jean-Pierre, and very good morning to everyone, or good afternoon, good evening, wherever you're tuning in from around the world. My name is Barry Sander. I'm an assistant professor of international justice at the University of Leiden. And welcome to the 4th day of this webinar series on teaching international law. We're delighted to have you with us. We have 2 fantastic webinars ahead of us today, the first of which before us now on new directions in core subjects of international law teaching. And then later on, we have the international law teacher. So lots to look forward to. So what I'd like to do really is just introduce our wonderful chair for the first webinar today, Ezekiel Hefez, who is a thematic legal advisor at Geneva Call. Prior to this, Ezekiel worked as a field and protection delegate and as head of office of the ICRC in Colombia, Afghanistan, and the Democratic Republic of the Congo. So we're delighted to have Ezekiel and the panelists with us today, and it's my delight to hand over proceedings to Ezekiel to kick us off. Thanks.
Thank you very much, Barry, and thanks also to Jean-Pierre and to the British Institute for organizing this. I think it's a wonderful webinar that we're going to have today with wonderful speakers that and I'm very happy to actually be chairing today's event. So as just a few words, as Barry said, I'm thematic legal advisor at Geneva Call. I mean, a bit of context, Geneva Call is a humanitarian organization that engages armed groups on humanitarian norms. We go to different contexts and we provide trainings on humanitarian norms to various armed actors. So this is why I'm very happy of chairing this webinar on new directions in core subjects of international law. We have, as I said, wonderful speakers. I'm going to be giving the floor to each and one of them in a few moments, but as Jean-Pierre said, please do not hesitate to ask questions in the chat box. I'm going to be sharing those questions with the different speakers. So without any further comments, I'd like to give the floor first to Emily Padden-Rhodes and Rebecca Saturn. They're going to be speaking about emotional character and IHL pedagogy, practitioner training in humanitarian protection. Emily is an assistant professor of political science in Swarthmore College, where she teaches courses on international relations, human rights, and humanitarianism. She received her PhD from the University of Oxford and has been a visiting scholar at Columbia University, International Peace Institute, and the European University Institute in Florence. And her research focuses on civilian agency, civilian protection, armed conflict, humanitarianism, and peacekeeping, and ethical decision-making in war. She's the author of Taking Sides in Peacekeeping, Impartiality, and the Future of the United Nations, published by OUP in 2016. And she's going to be presented with Rebecca Saturn, who's a Leverhulme early career fellow at the University of Edinburgh, where she convenes the LLM course in human rights, conflict resolution, and conduct research on emotions and humanitarian negotiations. She received her PhD in international law from LSE in 2018 and has published her book with OUP in February this year. So you have the floor, Emily and Rebecca.
Thank you so much. Thank you, Ezekiel. And thanks also to Barry and Jean-Pierre and to Bickle and the whole organizing committee behind these events. We're delighted to be here today, and I will be quick because Emily and I are going to split the time. So we'll try to strictly stick to 7 minutes each. So here goes nothing. I'm going to share my screen. So just give me a second here to get the slides up. Okay, so that looks like it's working. Okay, so how we'd like to run this presentation today is really Emily and I have been working on a joint project where we're trying to have a conversation across different settings where we think that both law and emotions are in play. So we're trying to think through the role of empathy and emotional intelligence in two different settings. One is the law school classroom or legal education, which I'll focus on today. And the other is humanitarian protection work, which Emily will focus on. So to start us with the legal education setting, the context that I'm speaking about here is a course that I've been convening for 3 years now at Edinburgh Law School, and it's called the LLM course in Human Rights and Conflict Resolution. And just to give you a sense of this photo is from the before times when we gathered physically in the good old days. But this course, to give you an overview of it, I'll come back to how it's organized and why we might want to teach emotions in this setting. But before I get into that, I just want to say how I started thinking about this is I'm working on a 3-year project about the role of emotions in international humanitarian law. And I've been thinking about how practitioners working in conflict settings deal with their own emotions and engage with law in their daily work. And as I read more about emotions in practice, I started thinking, why not teach law students this in real time as I'm learning it? So why not before I'm finished with the literature review and the learning, why not start a conversation in the classroom? So that's what led me to experiment with adding a module on emotional intelligence in my teaching. So to tell you what this course looks like, the regular course was designed by Christine Bell, and it runs through topics like international humanitarian law, international criminal law, international human rights law, but all of this is focused on the peacemaking contexts. So we're looking at things like the Belfast Agreement and asking, is this a legal document? We're talking about transitional justice, the role of amnesties in peacemaking, and so on. Also issues like gender justice and self-determination. So initially what I wanted to do is find an emotional intelligence skill that matched up with each of these main topics. And I realized quickly that that was stopping me from starting at all because it was almost impossible. So I gave myself permission to instead come up with what I thought were the 8 most essential emotional skills that I wanted the future international lawyers to know. And so they don't match perfectly with the course. Now I want to just say something quickly. Why would we teach LLM students emotional intelligence? Well, in this context, really the case is strong, and I would argue we should do this in all law school settings anyway. But in this particular course, the students that are attracted to it are going to be working for the UN, the AU, the EU. There'll be aid workers, negotiators, mediators, activists, civil society, and so on. So these are people who are going to be possibly in the future applying international law, but also called on to have some level of self-awareness, empathy, reflexivity, capacity for thinking about things like power and privilege and inclusivity in their work. So it's kind of a perfect setting in which to teach these skills. And why now? Why in this moment? Well, I think the field of law and emotions, this field of scholarship has really taken off. It's a very rich space in which people like Emily Kidd-White, Susan Bandes, Terry Maroney, Gillian Calder, and others are thinking about the connections between affect and the legal dimension. And then in the US, we have the movement for the Contemplative Lawyer, which is really arguing for law students to be learning mindfulness and to be learning how to meditate in law school. And I think we have, with changes in technology and changes in different sectors professionally, we have a growing appreciation that our students are going to need different kinds of soft skills. And as Emily will talk about, there's really renewed interest in training and pedagogy for practitioners in the field. And for me, all of this comes together in a sort of perfect storm with COVID, because I had students this year who were feeling their feelings and wanted to talk about it. So it was perfect timing. And I should say that half of the course was in person and then half went online. So I had to pivot the course halfway through to teach emotions virtually, which we can talk about in the Q&A. Now, I won't take up too much more time, but I just wanted to really quickly walk you through how I did this. And I don't intend to present this as a set of best practices, but rather just a sort of initial foray. So the top skills that I wanted my students to learn were active listening, self-awareness, mindfulness, empathy, creativity, thinking about power and privilege, curiosity, and inclusivity. And this, as I was teaching this course, Black Lives Matter was at the forefront of everyone's minds. And so I was able to use the sessions on inclusivity and power and privilege to teach students how to think about things like positionality, their own identity, unconscious bias, and things like that. So I include all of those things in this wider concept of emotional intelligence. So let me just quickly show you, for things like active listening, they would read a very short exercise on how to listen actively, and then they would have to do a homework assignment where they applied the skill, and then they would keep a course journal that was reflective and where they tracked their learning. So what we're also trying to do is prepare them for when they are practitioners to have skills in reflexivity and how to think about their practice. And I'll just highlight a few others maybe. For creativity, for example, we listened to a podcast about choirs and prisons and peace building in that context. And Mary Cohen, who was leading the session, didn't call people prisoners. She talked about insiders and outsiders. And so through this assignment, students agreed that we could be creative in conflict resolution, but this led us to have a conversation, should we be creative with law, and what are the limitations to that? And so I don't want to take up too much more time with this, but maybe what I'll do is I'll leave it there and I'll pass on to Emily. And in the Q&A, if anyone wants to hear about how I managed the other weeks of the sessions, I'll just come back to it then. Thank you very much.
Great, thank you so much, Rebecca. And I'll just echo also my thanks to her thanks to the organizers of this for including us in the series. So in this second part, I am going to focus on the importance of emotional intelligence and specifically empathy for humanitarian protection work, which takes place in a space governed by IHL. So why empathy, and what do we mean by empathy? So research on empathy has really thrived over the last decade. From neuroscience to psychology and behavioral economics, scholars have analyzed how empathy impacts individual feelings and motivations and how levels of empathy relate to things like prosocial and antisocial behavior. When we think about empathy, there are really two elements, and they're integrated. They're not totally separate. The first is affective empathy, and this refers to the sensation and feelings one has in response to others' emotions. So it's akin to I feel what you feel. And this capacity we have as humans is ingrained in us. It has a neural basis in our brains. The second element is cognitive empathy, and this involves a form of role-taking, a role or perspective-taking, in which an individual recognizes and understands another's individual's mental state. So it's more akin to, I understand what you feel. And as I said, these elements are not separate. They work in concert. And so we need to think about it as a sort of integrative model. As humans, we are hardwired for empathy, but this doesn't mean that it is a fixed trait. The development of an empathic capacity and the expression of empathy are shaped by a range of factors, and these include genetics, personality, social context. So in this sense, for whom and how empathy is experienced, as well as the ways in which it impacts behavior, can vary considerably. I should also add that research indicates that too much empathy without the ability to self-regulate can be harmful. Individuals can feel overwhelmed and distraught and distance themselves from the individual that they feel for. Also, the inability to distinguish one's feelings from another can result in what psychologists refer to as emotional contagion, or the loss of agency and self. So based on our reading of this literature and my research and Rebecca's research and the conversations we've had over the years, we've identified 3 core empathy-related skills that we believe new and seasoned practitioners of humanitarian protection work could benefit from. And this is already being incorporated into some trainings in different organizations. I'm going to say briefly a little bit about what these are, and then I'm going to outline an example of an empathy exercise from a training that I observed in 2019 in the Middle East. So what are these 3 different skills? The first is the ability to emotion regulate. This is important because humanitarians will experience empathy by virtue of being human, but also because they are proximate to suffering. Their work entails them getting close to suffering. And so individuals need to be self-aware. They need to be self-aware and they need to be competent in dealing with their emotions, and in particular with the surplus emotions. And in certain situations, failure to do so could cloud judgment and impede their ability to meet the IHL requirement of delivering humanitarian assistance impartially. The second skill is the strengthening of perspective-taking faculties. Evidence suggests that perspective-taking can reduce biases against particular groups. It can increase cooperation and trust, as well as sensitivity to injustices done to others. So this is a second skill set that's really important. The third relates to the social dimensions of empathy. In addition to understanding another's feelings and beliefs, empathy provides insights into how one's own actions, including applications of IHL, may be understood and felt by others. So for example, during humanitarian negotiations, aid workers may in some instances avoid law talk and focus on relationship building in order to ingratiate themselves with their interlocutor and establish their own legitimacy and build trust. And this may especially be the case in a particular instance in which a given IHL rule is at odds with the interests and needs of the conflict actor. So how might empathy be incorporated into humanitarian training and protection work in particular? I'm going to give one example from a training that I attended in the Middle East in 2019. And this was part of research that I'm conducting on the role of discretion and decision-making in protection. So the organization that hosted this training is a civilian protection agency. They work in conflict settings and they seek to protect through unarmed strategies and including through protection through physical presence. The work is heavily field-based. It's carried out by teams that are deeply embedded within communities. And these teams are diverse. They're comprised of international staff as well as national and local staff. Empathy is critical in this work. It's critical from an interorganizational dynamics perspective. It's critical for engaging communities, particularly as this work entails proactively engaging all actors, including instigators of violence. So for example, a staff member who maybe at one point in time lived under a particular armed group's control and who may have even lost a family member to that group may, through their work in this capacity as a member of this organization, find themselves in a position where they now actually have to engage with a former member of that group or a dependent of that group. So what about training? What does this look like in terms of training? So much of the training that I observed was experiential. It was meant to mirror practice. And a key objective of this training was to cultivate many of the skills that Rebecca mentioned. And I'm just going to mention one exercise that was aimed at honing an individual's empathy skills and in developing emotional resilience. The exercise, which is conducted in small groups, consisted of a role play in which each participant read 6 short character sketches of a person that they are likely to engage with in the course of their work. They were asked to internalize this character, and then in 30-second intervals, each separated by the ringing of a bell, each member of the group was asked to speak as though they were that character in their native language. When everyone had spoken as that character, the group rotated roles, and this continued until the entire group had embodied, so to speak, each of these characters. I participated in the exercise. It was incredibly emotionally charged and difficult for many involved. For some in the room, these roles were not fictional. They represented people that had done horrible things to them and their families. But as the facilitator explained at the beginning of this exercise, I quote here, "The exercise is important to our work. It is our work. I'm going to ask you to really stretch yourself so that you can begin to know your limits. The challenge for us, the challenge is how to connect with humanity and carry it with us without it crushing us," unquote. So I'll end there. Thank you so much.
Thank you very much, Rebecca and Emily, for this presentation. I see that there are no questions so far from the audience, so I encourage the audience actually to ask questions. But I have seen this happening in other conferences, so I'm going to take actually the role of the chair, and I'm going to ask you two questions before we move to the next presentation. So the first one is actually about the last example that you gave in terms of the role-playing exercise. So can you tell us a bit more about the audience of that role-playing exercise? My experience is that it's not that easy to make this type of exercises with parties to the conflict. So with armed actors, it might be easier to do it with civil society organizations, or it might be actually very hard with victims. But still, I have the feeling that with what we call as civilians, it might be easier to organize than with armed actors. And the other is not so much of a question, but is as a reflection. And as I see that from your presentation, I see 3 different levels where emotions can be discussed, if you will. So the first one is at the university level, and a bit of what Rebecca explained. The second one is within humanitarian organizations, so with their own stuff. And the third level would be with external stakeholders. So it could be victims, could be parties from conflict. So just to be clear about these 3 levels where emotions are discussed. So I will give you 2-3 minutes to you, and then we can move to the following presentation. Thank you.
Great, thank you so much, Ezekiel. So, and apologies if this wasn't clear. The audience were staff members of the organization. So this was part of a pre-deployment training. I was participant observing as a researcher. As I mentioned, the staff, the makeup of this organization is quite diverse. The international staff itself is very diverse, drawn from a number of different contexts. And as I said, the national staff is also very diverse. So the participants in this exercise, and everyone participated in the exercise, were the members of the organization. And I entirely agree that being able to carry out this type of exercise with a broader group of people, with a broader audience, including actors within a conflict landscape, would be more challenging than within an organization. Having said that, though, I do think that, very helpfully, you're breaking it down into 3 different levels, underscores in the 3rd level that you mentioned, external stakeholders, the need to actually think about these emotional skills that Rebecca and I are talking about, and including the role of empathy as part of engagement and part of outreach and the work that's to be done, particularly in the field of protection, in both for organizations and other actors involved in conflict areas. But I'll let Rebecca chime in here if she wants to add anything.
Thanks, Emily. I'll be very brief. Thanks, Ezekiel. I think that's really helpful, actually. And on this question of the 3 levels, Emily and I are working on a sort of conceptual framework where we think about axes of empathy. And one framing we were thinking of is the humanitarian actor who negotiates with the armed actor. And we're thinking about the 4 axes along which empathy would be in play. So we would have the humanitarian actor's empathy for the civilian population that they're seeking to protect. We'd have their empathy for the armed actor that they're interacting with. Then we'd have the armed actor's own empathy or lack thereof for the civilian population that they might be harming or could be helping. And then their feelings for the humanitarian actor and the humanitarian actor's values. So a framework we're thinking about is setting up a sort of matrix like that, where we show the way in which empathy is functioning on different levels. And part of what humanitarian actors might need to do in a scenario like that is regulate or manipulate or cultivate the empathy of the armed actor for both themselves and the civilian population. So that's one way in which we're bringing this 3rd level of stakeholders into the paradigm, if that makes sense.
It does. Thank you very much. And actually, in the meanwhile, we got different questions for you. So we got 4. 2 of the questions, I'm going to put them together because I think they address similar things. So one is about, it comes from, actually, there are 2 people dealing with similar issues. So it's about the response of the law students. So one is from a colleague saying that she had taught mass atrocities online last year and found that students were more impacted by emotions that usually perceived. And the other question was in a similar line is, how do law students respond to the topic of mindfulness in a law course? And if it is hard to motivate them for soft skills as opposed to the black letter of the law.
Okay, thank you so much to the audience for those questions. And Ezekiel, just cut me off if I go on too long. So these are live questions that I had to grapple with in the pandemic specifically and in switching learning online. So on the issue of students feeling very emotional this year, it was a huge thing in our classroom. And sometimes as someone in the law professor or instructor position, I had the instinct that we needed to cabin some of this off and put some things to the side so that we could focus on the topics and engage with the law. But because this emotional intelligence module was built into the course, it also gave us permission to not act as though everything could be separated and that the learner wasn't in the room in their body. Right. And I think Gillian Calder has written a beautiful article about this called Whose Body Is This? About learning emotions in the law school classroom. And I think this year with the pandemic, what we saw is that our students come to us with histories, with experiences of trauma, with, embodied approaches to learning and how they, I had them lined up in masks in the classroom setting, socially distanced. They couldn't look at each other. We couldn't have our usual debates, you know, and then once you go online, you're all in little squares on the screen. And so this was an ongoing juggling act. And I felt very lucky that I had built in time and space for emotions, because it just built and built. And the students who were, to answer the question about mindfulness, this really became an interesting conversation also about gender and stereotypes in the classroom, because I had 22 female students and 1 guy. And, you know, it was like kind of a running joke in the classroom, like, because the syllabus was up when students had to choose what classes they were taking. And anyone who looked at it knew there was going to be this emotional component. So arguably my experiment doesn't tell us what would happen if you had students who weren't amenable to this kind of learning, right? Because they self-selected into the course. But we had some fun talk about gender, and something my students brought to the classroom this year is moving beyond sort of gender binaries in peace building and talking about fluidity and thinking across those boundaries. So all of this fed together. And I would just say, giving students the space where some of their homework related to emotions and keeping a course journal, that could have been a bit frustrating for them as extra work. But one of their exam questions I built in was they had to advise the UN Secretary General on how to compose his peace negotiations team, based on whether they could successfully negotiate for amnesties from a legal perspective, and based on their emotional intelligence skills. So there was a reward at the end of the course if you had thought hard about these issues, but you could opt out if it didn't feel right for you. You could pick a different exam question. Thank you.
Thank you very much, Rebecca. There are other questions, but I suggest we move to the next session, to the next speakers, and then if we have the time, we come back to the questions for Rebecca and Emily. So now I have the pleasure to present George Wilkes and Magnus Linden. They're going to be, their presentation is entitled Should Militaries Teach IHL and Ethics Together? Comparing the Attitudes of Educators Internationally. Dr. George Wilkes is a founding director of the Project on Religion and Ethics in the Making of War and Peace at the University of Edinburgh, and a visiting fellow at King's College London School of Security Studies. And he has taught in at the universities of Cambridge, Leuven, Edinburgh, and Birmingham. And Dr. Magnus Linden is an associate professor at the Department of Psychology at London University, and his research interests lie in the psychological aspect of aggression, group conflict, human rights violations, especially in connection to armed conflicts and terrorism. I give you the floor for your presentation, Magnus and George.
Thank you very much. Thank you all, co-organizers, hosts, and Ezekiel as chair. Magnus and I are going to present some work that is not a million miles away from that very interesting research that you presented, Rebecca and Emily. Very stimulating for us. We've designed a survey-based study on whether international humanitarian law, law of armed conflict, and military ethics should be taught together, separately, and we're focused on the attitudes of educators in military institutions. So we're going to present results from our survey of military, of educators who may be civilian or who may be military personnel who teach either law of armed conflict, international humanitarian law, or military ethics, or both, in a military institution. Our motivation for this is to take to play a useful part in the discussion which the International Committee of the Red Cross has been advancing recently. What is effective teaching of international law in military context, in teaching armed actors to comply with the law? What is effective? Should ethics be part of the transmission of IHL? So some experienced observers, when we began to talk about this with them from military backgrounds, said, no, that's an entirely spurious idea. and that's on the basis of their experience in teaching either military ethics, they think lawyers are a nuisance, or in teaching law, they think ethicists are a nuisance. So on the basis of that expectation, we thought it's worth a study. I'm going to hand over to Magnus, who'll present how we took this on, our method, and the beginning of our survey findings, and then I'll come in nearer the end again.
All right, George, are you the slide manager?
Yep, and I'm a slide manager.
Yeah, perfect. All right, thank you very much, George. If we should be really honest here, it's really George who is behind this project. He is the main architect around it, and I am the method. I'm organizing the methods and the statistics. We have other projects ongoing, for example, about empathy and Holocaust education, to refer to the prior presentators. And I have a lot of interesting stuff there I could give to you concerning empathy. But that is another question. I'm here to say something about the methods and also present a bit about the results. I will also say something about limitations. This is a pilot study, and all of you that are acquainted with statistics know that there are certain rules that we have to follow concerning power size or sample size and such stuff. But what we did was that we developed a survey, which was mainly an online survey, which was put out to different military institutions. And it was open-ended questions, and actually we developed 22 themes for that survey, and 21 of them were self-developed. And we actually went out to the whole world with this and tried to get as many responses as we could. And at this point, we have 149 respondents from more than 10 countries. And we have very much data. And for this presentation, we choose to divide and compare those that had the capacity of teaching law compared to those who have the capacity of teaching ethics in a military context. That doesn't mean that underneath these two labels, there are a lot of professors, military officers, academics, and we have divided them into two groups based on their capacity. And we have much other types of groups here, like religious groups, like if they have been working as military officers or been active in the field, and we have a lot of data. So all of you who are interested, just contact us and we can give you information for whatever you want. Yeah, and you can see the first page of the survey there at the picture. You can also see demographics for those two groups, the law and ethics instructors, and you can see that they are quite comparable, both concerning age and concerning gender. We have 4 and 5 females, and I have also made statistics on that, and there aren't any differences between the groups. Concerning procedure, it is an online survey that is still open, but we have taken the data up till January last year in the analysis, and the recruitment was through personal contacts mainly. And when I compare these two groups, there are 32 ethics instructors versus 25 law instructors. I have used both parametric and non-parametric statistics, since you all know that since this is a pilot study, we might have a power problem with such low numbers in each group. If we're going to publish a study comparing these two groups, we should, of course, increase sample size in both these capacities. But for the sake of this pilot study, we have made some interesting findings. There are other categories that have much more participants, but to counteract for the problem of sample size, as I said, I did parametrics and non-parametrics tests, so t-tests versus Mann-Whitney comparisons. Please, George, next slide. This is, for example, teams that we have developed, and all of you who are acquainted with surveying knows that usually we have items that we, for example, taking empathy as an example, when we measure empathy quantitatively, we have a certain number of items that we add together, and that becomes an index of empathy that we correlate and compare means and whatever we do. In this survey, we have actually developed a lot of new items, which is not really basic scales in that sense, for example, like empathy or personality. And instead we have tried to develop certain underlying themes that are interesting in this context. So some of our work will be to see if we can build scales around this, and some works as scales, but others do not. But these are the themes that we have been investigating, and these are examples. As I said on the prior slide, that we have 22 themes, and you see some of them here. And what we have done is that we have compared instructors of law and instructors of ethics concerning these different types of themes. And we have made, and they have rated on a scale of 5 response steps. So it's an attitude scale. And we also have open-ended question, but that would not be, we will not present those in this presentation. Please, George, take the next one. And we will give you some examples here on what we have found actually. And as I said, all of you are interested, please contact us and we will give you more information. And these are one of the themes that we were investigating. Are law and ethics education consistent with each other? And when we compared the two capacities with each other, they thought that the core principles are seen to be the same. So there aren't any differences in the core of what we are going to teach. And also the primary concern of each is the same. They also see no differences in teaching about core features and also applied perspectives. For example, POWs and how you treat women and children and how you should handle civilians and so on. And that weren't any difference between higher and junior ranks as well. So that was similar. And also the both groups thought that the two subjects should be taught together and would strengthen the impact of both student courses on the students, that they were combined in a way. What we saw was that there were differences in how ethics and law education should be made. And you can see the items there. And for the first item, you can see that there is something called mean, and there is a mark saying that was higher, which actually means that that law instructors had a significantly higher mean level. So there was a significant difference between groups on that item. And also we saw a significant higher mean on the next item there. I see weighty differences between ethics and law education for all ranks, but I see no necessary conflict when real case studies are introduced. So this gives you an example of how we have been working with this. And George will now continue to present more results and also a conclusive thought about the study.
Okay, so on this next slide, we asked about the effectiveness and the design of a course when teaching either law of armed conflict, international humanitarian law, or ethics. So separate questions for those. And where there are no differences between the law educators and the ethics educators, I think it's quite significant given the expectation of many that these are two completely different animals who don't work well together. But very often we have very similar sets of responses or trends. There are no differences in the use of different methods to evaluate effectiveness. A course, both groups said, needs to be firmly based on conceptual foundations. So not distinction between technical law and general ethics, for instance. The use of practical discussion of cases was important from both perspectives. A course must be backed up by the most senior officers. A course needs to be designed to affect students personally, which is significant finding. This was affirmed by lawyers as well as ethics educators. A longer ethics course increases the likelihood of students utilizing their learning in their careers. a point which is not accepted by all professors in the military academy, of course. Difference is that when presented with the contention there's no satisfactory way to measure the effectiveness of LOAC education, ethics educators were more likely to agree. And law instructors were more likely to agree that the legal coursework needs to be integrated across the curriculum. Not sure how significant we should see that. Values in teaching, there were no differences on the point that private values can be very important for students in decision-making and in resisting peer support, as long as these values are aligned with professional military values. So for lawyers and ethicists to be agreeing on that is quite significant. The impact of learning, the impact on learning of social media, of national media, of religious traditions and films, both lawyers and ethics educators are saying, we see this in our classroom, that this is significant, something that affects our teaching. You could extend from that. The difference is, respondents were asked, have they observed a significant impact on learning in ethics classes of long-established social or cultural groups? You might ask, how are lawyers even responding to this? But it's the ethics instructors who are more likely to say yes, and the law instructors are more likely to say, okay, we have a case about peacekeeping. The basis for judging whether gross violations of human rights require international action will be the principles of natural justice. Is the law instructors more likely to say yes to that? Another case here, I'm going to speed through this one to make sure we come to an end. A case about the conditions under which armed force may be used in self-defense. And we asked a number of questions. There were no differences for a number of the points that we raised. Some differences, however, I'm just showing you there. I'm going to speed through to the more interesting one from the perspective of our last talk, empathy and judgment. So the effect of training on empathy, both lawyers and ethics educators were equally likely to value this, to stress this. When asked, are there resources in your educational context that help students to model their behavior on exemplary, empathic and compassionate figures, both lawyers and ethics educators are saying yes to that. And there was a slight difference, or a significant difference, let's say, in relation to one point, is where we presented the option. This is a difficult area because our personality traits are preset, either to allow empathy or not. And law instructors were much more likely, or significantly more likely, to agree with that. Thank you for listening. We look forward to partnering with you in civilian or military university contexts. If you have an interest in this topic and in working with us in spreading the conversation about how military education should be done, how it's effective, we would be glad to share our analysis and to be a part of a conversation with you, how educators think we should make more effective teaching and better deliver on learning outcomes. Thanks.
Thanks.
Thank you very much, George and Magnus. This was a very, very interesting presentation, and I think it was very much complementary to the one by Rebecca and Emily. So it was actually a good follow-up on that. I know that there are a couple of questions in the chat box, and I encourage everyone to actually do this if they to foster the discussion about these topics. I'm going to do it as I did before. I have a question for you, and then I'm going to open for the question that we have in the chat box. And for me, it's quite interesting because when working in the humanitarian sphere, when providing trainings, one problem actually that comes out quite often is whether you can teach the same content, if you want, to different audiences. So here you focus on militaries, of course, But my question is whether you would have the same reflections in terms of providing trainings on IHL to in universities, to civilians, to civil society organizations, even to victims or communities that are in need of knowing international humanitarian law, but also ethics. I mean, if your conclusions would be similar or not. Yeah, thank you.
Great. Oh, I'll jump in with that. Magnus, you can follow up if you like. Great question. Context is everything, and for us the question of how learning is made personal is very significant. How professional responsibilities are understood is very significant. And so even amongst our respondents who all come from military contexts, we expect a great difference of understanding about what teaching relevant law is, what teaching relevant ethics, how to get students to engage. So much more so if we're trying to have stakeholders from the field, if you like, in Geneva Calls context, for instance, or if we're trying to get very senior generals to take these courses more seriously. We're engaged very much with educators who are teaching ethics, who are teaching IHL or law of armed conflict, and for them to be able to do their teaching better, if they believe that they need more time, they have to persuade generals, a committee of generals perhaps, or they have to persuade the commandant, the head of the military academy. And that varies very much according to the type of course that they're delivering and who's in control of it, which stakeholders are controlling those kind of decisions. So we are hoping that by presenting these educator perspectives will reach into these very different contexts, and maybe also insofar as humanitarians from the ICRC, from Geneva Call, from Christian Aid, for instance, as they're trying to engage with militaries to make their teaching about protection of civilians more effective, we hope that we'll be showing that they have partners in the teachers who often take their courses really, really seriously, is what their career is about, and they believe that they can be effective or could be effective. So that conversation across those differences is really where we're trying to push our work.
I can also add to that there seems to be some prerequisites for being open to this type of training. We have an ongoing project where we have evaluated Holocaust education in a high school context. We have a study on that is under review at the moment, me and George and some others, and we have found that people who are students that are most open to that message, the Holocaust education message for tolerance and democracy, are actually the ones that they are more empathic than the students that are not open. So we see both a significantly higher level of perspective taking and a significantly higher level of empathic concern in those students that reports that they have learned much and that they are open for this type of teaching. So what we conclude there is that if you're going to work with this type of concepts, maybe you need to have some kind of pre-training where you teach, like you, Rebecca and Emily do, like you could train empathy before letting people be open for this type of education. So you might need to think in steps here. First, trying to increase empathy, decrease social dominance, for example, and then insert a theme that is going to be taught, for example, about law or ethics, to be able to open up people before they can take the message home.
Wonderful. Thank you very much, George and Magnus. We have one question that I'd like to share with you. I think Julie Fraser is there. She's muted.
Hello, can you hear me? Oh, sorry, I didn't expect to be unmuted. Sorry. Very pleased to be here. Thank you so much for organizing this and for all the presentations. I've really enjoyed it. My question really to George and Magnus is about the role of religion in your teaching, because I'm thinking my research has also touched on religion, and I'm wondering what sorts of ethical approaches you used, how you defined ethics, also how you defined law, and whether you saw religion as being part of ethics or as being part of law, what types of religions you used, or or came up in your teaching, depending on your students. So just curious to learn more there. Thank you so much.
Great. I'll start again, Magnus, and you can follow up. Julie, yes. Thank you very much. Very pleased to have a fellow researcher with this interest. So we are interested not in defining law and religion, but in seeing how educators and the institutions that they teach in, how they define the core of ethics, the nature of ethics, the relationship between private ethics and professional ethics. So these are all open questions for us, and we sought through the open questions in our survey, we sought to see how the assumptions about the concepts involved, the concept of what is religious, what is ethical, how they are seen to be practical in the case of a self-defense case study, for instance, or in the case of a humanitarian intervention question. Again, we're not defining that, we're asking the question of the survey respondents. So the kind of expectations we have about different conceptual framings that do draw on religion are the following. What are the principles of justice? Are they the principles of natural justice? Do Catholic and Protestant and Orthodox Christians agree on that? Do Americans and Europeans agree on that? Do lawyers and ethicists agree on that? So we've findings relating to that. Is a good ethical decision and is the right judgment a matter of finding the right outcome or avoiding the greatest evil? Do Protestants and Catholics and do different denominations within the Protestant communities agree on that? We've got lots of chaplain responses, since chaplains often teach ethics and are often given training to be the ethics teacher in a military academy. So the question deserves to be begged, and many ethics educators avoid it. Many military institutions avoid it. So there are plenty of Catholic educators in a majority Catholic setting. For instance, I'll pull a random example out, in Brazil, perhaps, or in Vienna, perhaps, where the assumptions that undergird ethics teaching and law teaching are not unpicked because it's not necessary. They're rather assumed, and those assumptions can be quite different from the way that Israelis or Moroccans would do this kind of teaching. Thanks for your question, Julie. Magnus?
No, we have short of time, so I will not add something. But Julie, interesting question. Please email us. We have a lot of data on the things you wonder about. So just come back to us. So thanks.
Thank you very much, Magnus and George, for this very interesting presentation. Of course, if you have further questions, do not hesitate to use the chat box. And if we have time in the end, we come back and to continue the debate with George, Magnus, also with Rebecca and Emily. So now we go through to our third presentation, Dr. Vidya Kumar. She's going to be presenting, her presentation is entitled The Utopic Place of International Labor Law in Public International Law. So we're leaving IHL. She is based in London. She's an associate professor at Leicester Law School, University, and she holds a PhD from the University of Oxford and degrees in political theory from Canada. She's also a faculty member of the Institute of Global Law and Policy at Harvard University and has been a visiting research fellow at LSE, at Melbourne Law School, and at the Department of Law of Humboldt University in Berlin. Vidya, yeah, I give you the floor.
Wonderful, thank you. Just going to put my timer on here. So first off, a huge thank you to Barry and Jean-Pierre for organizing such a fantastic series. I can't wait to watch all of the recordings myself. It's just going to be so important and instructive. Also, thanks to Liam for his technical support today. Yes, my topic may actually touch a little bit on armed conflict, but not in the way that the previous topics have discussed armed conflict. And in fact, the provocative question my brief talk will attempt to address as a pedagogical question for international law teachers is, what is the place of international labor law in international public law? How would one characterize this place or origin story when teaching international law? Clearly one option would be to tell the story as the history of ostensible great men involved in setting up and envisioning the International Labor Law Organization, to see how they shaped international law and how international public law has been shaped by these great men more generally. And this work is useful and important, but it also doesn't tell us the full story. And what I want to do today is to offer a different story, one which speaks less about great or founding men of international labor law, but turns its attention to the pre-configuration of great events, great struggles, great movements, and great uprisings that have played decisive and foundational roles in the creation of international labor law and international labor law institutions. This is a story about recovering a revolutionary place of international labor law in international law and international legal teaching. In saying this, I recognize that the place of international labor law in international law is also about choices that international teachers and scholars make in their practices, producing knowledge, writing textbooks, articles, and syllabi that delineate the nature and fundamental features of international law. And here, international law occupies, I would argue, at best, a utopic place in international law. And by utopic, I refer to the etymological meaning of the word utopia, that is, as a non-place. Unfortunately, because of time constraints, I'm going to focus my comments today on the revolutionary place of international labor law and international law, although I won't have time to discuss the utopic aspect, and hopefully this can get picked up in the questions. So for those unfamiliar with the field, which in my experience includes most public international lawyers, international labor law can be broadly defined as the body of rules and duties of employees, employers, trade unions, governments in regulating the workplace. That's a broad definition. Often there are narrow definitions that are applied by international labor law textbooks, saying that international labor law is really that part of labor law, domestic labor law, which has an international source. However one wishes to define the topic, broadly or narrowly, most international labor lawyers agree that the International Labor Organization, or ILO, has been the central and preeminent institution in the formation and enforcement of international law. Following them, I will focus most of my comments about international labor law on the ILO organization as the main body of the creation of international labor law. And a question which arises, and one which I believe can shed light on the place of international labor law in international law, is, why does international labor law, as we understand it today, exist? Reframed for our purposes here, I want to ask, why does the ILO exist? Standard accounts explaining the reason for international labor law and the ILO overlap with the story that the ILO tells itself about its own origins and founding moments. The ILO website says that the ILO was created in 1919 as part of the Treaty of Versailles that ended World War I, to reflect the belief that universal and lasting peace can be accomplished only if it is based on social justice. In their 2009 work examining the ILO as it approaches its 100-year anniversary, Rogers, Lee, Swepston, and Van Dale, three long-serving ILO officers, along with an ILO historian, observed that the ILO was created in 1919 as a means to promise social progress and to overcome social and economic conflicts of interest through dialogue and cooperation. This social progress explanation of the ILO's origins was recently amplified by Philip Allott in a piece he wrote in 2019 for an edited collection celebrating the ILO's centenary. In that piece, entitled "An Ideal World Like Our World, but Completely Different," he asserts, the International Labour Organization seems like something that has come to us from a better world that must have seemed to be a possible world in the eyes of certain visionary people in 1919. And added to this popular account of the ILO's purpose and origins, being located in the need for humanity to progress, to hope, and to strive toward attaining social justice, is an account of the ILO as a product of war. In fact, the very fact of the ILO was established by the Treaty of Versailles, a treaty ending the First World War, has led to accounts that suggest that the ILO's creation was a response to and a remedy for the scourge of war, with the end of war and interest in sustained peace somehow producing the idea of regulating labor at the international level. The ILO itself underscores this connection between war, peace treaties, and international labor law in its characterization of the First World War and the Paris Peace Conference of 1919 as marking a watershed in the 19th century movement of the idea of regulating labor law at an international level. And ILO scholars that I've mentioned earlier argue that war, in fact, was one of the primary triggers for the creation of the ILO. This, they explain, was because the First World War, with its savagery, mass mobilization, and widespread social repercussions, political leaders were open to fundamental change in politics, economy, and society, and to the building of international institutions which could engage all countries in common effort. Writing in the same edited collection as Allott, George Abisab repeats both the progress narrative story and the idea that the ILO was forged out of war, remarking that the establishment of the ILO in 1919 in the wake of the First World War marked a significant and new stage in the quote unquote structural evolution of international law. Until then, there were few islands of law, of the law of cooperation in a vast ocean of the law of coexistence. He says the great novelty of the ILO was that it ushered in a new kind of species of law of cooperation, a new generation of international organizations. Its institutional component based on common values, the ILO was avowedly created to promote social justice. Indeed, reading one of the preambles of the ILO Constitution supports this reading. Now, I have sketched popular and standard accounts of the origin of the ILO as a foundling of war and as a post-war or as a post-war institution pursuing social progress and justice necessary to maintain global peace and harmony, to contrast them with yet another often ignored and glossed over account of the ILO's foundation. And here I want to argue that international labor law, as we understand it today, is primarily and fundamentally a creature of revolution. This is the origin story which needs to be recovered and interrogated in international legal thinking and teaching. For much of it may turn on events today. This story I found more often than not in earlier accounts of the ILO's founding by international labor lawyers and historians, and these accounts repeatedly underscore the fact that the ILO was created as a specific response to the Bolshevik Revolution of 1917 in an attempt to reduce the growing attractiveness of revolution for Western European workers by creating an alternative vision of social justice reform. And as international labor lawyer Francis Maupin notes, the ILO had to face the implacable hostility of the Bolsheviks, who claimed to possess a definite solution of their own to the achievement of social justice. He continues, the ILO's reformist vision was diametrically opposed to the revolutionary option and Marxist vision of social progress, which claims that the alienation of the proletariat can only be eliminated through the overthrow of the regime of private ownership. It is hard to convey here the sheer fear of the spread of revolution across Europe following the success of the Bolsheviks in Russia in 1917, That fear was absolutely palpable in most Western democracies, including the United States and Canada. American historian, Canadian-born James T. Shotwell, who played a significant role in the formation of the ILO, captured this fear poignantly in his work, The ILO as an Alternative to Violent Revolution. Europe, east of the Rhine, he says, Europe, east of the Rhine at least, was still in the midst of revolutionary disorder, and there was grave apprehension of its spread in the Allied countries and even to Paris itself. Some measure of this fear may be estimated by the fact that on May Day, the government of the Clemenceau, the government of France, stationed 60,000 troops in the streets of Paris. This very palpable fear of the spread of revolution following 1917, the October Revolution, then became even greater a year later following the German Revolution of 1918, or the November Revolution as it is known, a revolution which would rid Germany of its feudal monarchy, but also which would terrify the UK government of Prime Minister David Lloyd George into advocating for the creation of an anti-revolutionary international labor law organization to quell worker unrest. Werner Sengenberger, who worked for the ILO from 1986 to 2000, has observed that although Germany was not a founding member of, or a founding nation of the ILO, and here he means, okay, so he says Germany was not a founding nation. In fact, it was a defeated power at that point of time, so it wasn't a founding member of the ILO. It, and here he doesn't mean Germany, he means the German Revolution, was indirectly responsible for exerting the pressure on its inauguration. During and shortly after World War I, social unrest, strikes, and revolutionary movements sprang up in Europe and even in North America, starting with the October Revolution in 1917. And in Germany, political uprisings, including the November Revolution, happened where groups of workers in the North joined the Navy for an overthrow of the government and a new political order of the country. The following day, revolts by workers and soldiers spread to Munich, Berlin, and other big cities, leading to the formation of a short-lived worker republics and the foundation of the Communist Party. In early 1919, the British Prime Minister David George Lloyd wrote to the French Prime Minister Georges Clemenceau, saying, "The whole of Europe is filled with the spirit of revolution. There is a deep sense not only of discontent, but anger and revolt among the workmen against pre-war conditions. The whole existing order in its political, social, and economic aspects is questioned by the masses of the population from one end of Europe to another." Okay, I'm going to stop there. But before I do, I'll just end with an answer to the question of why am I delineating in detail this historical account of the revolutionary origins of the ILO? What is at stake in highlighting this displaced and underexplored origin story of the international labor law for international law and international legal teaching? And I'll offer 3 preliminary conclusions about the significance of my attempt to resurrect and redeem this revolutionary origin story. First, it is to acknowledge that, like war, revolution is the mother of invention when it comes to many of the international worker rights and labor standards that we have today. Second, I offer this account to foreground revolution as an important concept and event, which international legal scholars often ignore in their understanding and teachings of how international laws and how international legal institutions get made. Revolution needs to be taught in international legal textbooks as much as war is taught, both as a catalyst for international lawmaking and the making of international legal organizations. And last, and perhaps most significantly, if it is the case that the ILO has been forged to decapitate the success of the spread of the emancipatory worker-centered revolutions, if that is the case, which George Abisab calls one of its ulterior motives, and Anna Peters calls its anti-revolutionary ethos. Is it perhaps time to reevaluate the ILO both as a possible obstacle to social progress, namely as an obstacle to much needed radical change to address the inhuman and exploitative conditions and plight of workers globally today, a change which international lawyers and many international law students in the 21st century would like to see? And I'll end it there.
Thank you very much, Vidya. This is a very, very interesting presentation. And I mean, I'm gonna do the same thing as I did in the previous two presentations, and I have two comments on this. And the first one is, I found it very interesting that at the beginning you used the word choice, which is not very common in legal debates because we are so embedded in, I would say, positivism and the black letter of the law that sometimes discussions about choices and mostly policy choices are not dealt with because, I think there is kind of we are afraid in the legal debate to speak about choices and policy decisions. So that I thought it was very interesting. And the other one, and I would like to relate your presentation with the previous presentations in terms of emotions and how emotions also influence lawmaking decisions. So in the end, the point that you made about revolutions and wars leading to treaties and the content of treaties is very much influenced by an emotional aspect. And if you actually go to some of the commentaries of certain conventions, and it's also interesting to see how they link emotions to states. So they say states had fears to do something. They were afraid to do it from doing something, or they were, it meant very much in favor of doing something else. So they relate this to the emotional aspect of the state that is behind that lawmaking. I don't know if you have any further comment about this, but I would really like to hear your thoughts. And then I know that we have another question by Barry that he's going to make it live.
Should I go first, or Barry, do you want to go first? Okay, so,
no, you go.
So just on the question of emotions and affect, I've actually written a piece on the way in which international lawyers address revolutionary failure, and in particular the Bolshevik Revolution. And I argue that it is affect and emotion which decides how they respond to the success or failure of the Bolshevik Revolution as an event with significance for international law. So my piece actually really does engage with this question of affect, but also affect is really becoming important in the study of history. So how are historical narratives created? What is included? How do individuals select facts? And what role does affect play in the selection of valid or relevant or pertinent facts, and the deselection of other facts? So I completely accept your argument about affect and revolution, because I think there's something there. The only thing I would say is what is peculiar and why I think I am so persistent in making this point about the non-place of revolution in international law has to do with the fact that there are many non-legal events that international lawyers recognize as foundational to regimes and treaties. So war is the obvious one, and Hannah Arendt would say revolution and war are the twin master processes of the 21st century. And so then my question is, why do lawyers only recognize war as part of the process of the 21st century? And the second point I would say is, it's not just war. If you look at the Holocaust and its formative effect on the the Universal Declaration of Human Rights and of covenants after this, there are many events which international lawyers have no problem saying were formative events and foundational events to the creation of treaties and documents. The fact that very few, if any, international lawyers discuss revolution or have it as a salient category in any of the textbooks or any of the syllabi is something to me which I find unusual. And then the question goes to what you were mentioning, Esquiel, that is this a matter of affect? Is this just I'm uncomfortable with the topic and I can't actually address it as an academic or a salient variable?
Fascinating. Thank you very much. I mean, we can discuss about choices and I would say policy choices behind all these debates for a while. I know we have a question by Barry.
Yeah, well, first of all, wonderful presentation. Thank you so much for that video. Really, really interesting. It's funny because I was just teaching yesterday, actually, from and using Hilary Charlesworth's piece on crisis and international law. And your presentation really triggered some thoughts about how what you're saying relates to Hilary Charlesworth's article, because, and you know, I'm sure you're aware, but for the audience, Hilary Charlesworth argues that, you know, international laws place too much focus on crisis situations, and in focusing on crisis situations, there are a number of repercussions of this, such as crowding out the kind of everyday atrocities that occur under the mantle of international law, and international law becomes kind of a veneer for the status quo. And so I really wanted to put your talk in conversation, if I may, with that piece and get your thoughts on that, because it's interesting because actually Charlesworth doesn't really discuss the selectivity of the crises that are focused on so much in that piece. And just listening to your thoughts about the kind of omission of revolution made me think of that. But I also wondered, what are the risks of a focus of international lawyers on revolution? Are there in teaching? Are there any risks that come with it? And maybe, you know, with a particular thought to that Charlesworth argument.
Yeah, great questions. I love that piece of Hilary Charlesworth. I mean, it's classic, it's defining. And the way I think about it is not that I would exclude revolution as an example of crises. So her argument works really well with my argument as well, with the only exception being that when we open international legal textbooks, there is a de facto periodization of the way in which the subjects are taught. So there's an origin story about Westphalia, perhaps, or Vittoria and contact, depending on whether you're a Twale, whether you're not. And these kinds of origin, so the chronology is often set out in terms of the identifying those subject matters that frame our understanding of international law, or that are foundational to it, fundamental features, I would argue, of it. Starts off with chronology. And what I would argue to you to say would be to say the chronology, the counter chronology that I propose isn't necessarily correct. It's just a different way of thinking about the organization of events and its repercussions. So what if we were to create an international legal textbook, which is periodized by revolutions, and then the fallout of that legally is addressed? What would that look like? That's partly the monograph I'm trying to write, is to say, what kind of imaginings would we do if we displace the variables that are getting sole attention, which war, I think, is a big one. Human rights is another big one. And the story of the ILO is not the story of human rights, as much as many people today would like to argue. So I would say what would be gained and what would be lost by re-envisioning the unfolding of salient international legal history in a way which periodizes different events. And they don't only have to be revolutionary. I mean, there's so many. I mean, they can be anti-colonial events. There's so many different ways to think about the way in which we would teach international law differently if we focused on different liberatory, for instance, events.
Thank you so much.
Thank you.
Thank you very much. Wonderful, wonderful presentation. Again, I think we could continue speaking about this, but I want to give the floor to our last presentation, Dr. Lindsay Mitchell. Her presentation is entitled "The Gender of International Human Rights Law: Uncovering Legal Academics' Views on Reproductive Rights in Legal Education." And Lindsay, she's an early career researcher and lecturer in human rights law at Aberdeen International, University, I'm sorry. She teaches human rights law, gender, sexuality, and the law and family law. And she has different degrees, one in Scottish law, then she holds an LLM in international law and a PhD that focus on how narratives on women's rights are used to justify military intervention. She's a founding member of the recently launched Gender Justice and International Law Research Network, which works on bringing together critical scholars of international law in order to promote gender justice. And she's currently working on a funded pilot project exploring how reproductive rights are understood within the wider human rights project. And something that I find very interesting, she's the editor of a forthcoming Routledge edited collection, Law, Power, and Justice in Game of Thrones. Lindsay, you have the floor.
Awesome. Okay, thank you very much. Let me just hopefully make the slides work. So can you guys all see that? Yeah, awesome. Okay, so again, thank you so much to the other speakers. This has been so interesting, and thank you so much to the organisers for moving this online. So today, what I want to talk to you about is basically some of the findings from a pilot study that I've been doing, but just to give you a little bit of background. So following on from the discussion that we were just having there, it's been almost 30 years since Charles Worth Chinkin Wright's famous feminist approaches to international law article. And I wanted to talk about where we are now with feminist approaches in the classroom and the visibility of women's rights. So I specifically want to focus on how we teach human rights law, even though this is often considered to be one of the more feminist or indeed feminized areas of international law. But I wanted to consider whether that is actually the case, or whether there is still in the classroom, whether there's still a focus on what's often considered core doctrinal scholarship that tends to focus on, civil and political rights and tends to reinforce hierarchies by focusing on public sphere rights that are often gendered or coded as male. So I'm going to speak very briefly about this pilot study that I've been carrying out, where I spoke to human rights academics, both in the UK and internationally, because I wanted to understand how they understood women's rights, women's issues when it came to teaching human rights, and how did they, or why did they use particular content, and why did they focus on particular issues and perhaps not others. So again, just brief background, the impetus for this study actually came from my own discussions teaching students when I convened a master's, I convened an LLM on human rights law, and I increasingly noticed a disconnect between my own research that very much went into TWAIL scholarship, post-colonial feminist scholarship, and I was interested in trying to unpick some of these stereotypes, around what, for instance, Ratna Kapoor would term the third world victimized subject of human rights. So I was increasingly interested in the scholarship around that, and the fact that there was an increasing disconnect between, even when I was teaching this, how my students understood human rights, and the fact that they were still welded to this idea that, human rights was very much something perhaps for other people, it was for people over there. And particularly when you spoke about the idea of women's rights, the students often conjured up this idea of, this victimized third world subject. And there was often a reluctance to situate things like lack of access to abortion, for instance, in the UK, which has something that was recently litigated at the Supreme Court. This was a real contemporary issue, and there was a real reluctance amongst many students to engage with that as a human rights issue. And I found this fascinating. So I have been doing this ongoing, it's a grant-funded study by the Society of Legal Scholars. They like me to use their branding, so it's on the slide. And basically, just to give you a little bit of background, I don't have as much information here on the methods, and I certainly haven't done as much of a deep dive into the data as the what we heard from previous speakers. So it's going to be a bit more of an overview. But basically, the idea was obviously to do all this in person, and it was going to be done last year. And obviously COVID has really upended the entire thing. So I used an online survey model of human rights academics. The survey is open, so I'll throw out a shameless plug. I will put a link in the chat function. So if anyone actually teaches human rights and wants to contribute, you're free to do so. So I used an online survey, and then I followed this up with in-depth interviews with various different human rights scholars to ask them their views on why they were including particular content, and what was the issues around this, what influenced their decision making, and ask them a little bit about student perceptions. One of the reasons that I was really interested in this is because, as you heard in the introduction, I'm really interested in the language of human rights. I'm interested in who is talking about human rights, who gets to talk about human rights, and who gets to define human rights. And perhaps tying this together with some of the other talks we've heard today, I'm really interested around the emotion that talking about women's rights often generates. So I wanted to see if I could find out, where did some of this language and emotion come from? I had also presented work at an interdisciplinary workshop, which was really quite helpful. It was an interdisciplinary workshop on reproductive rights, where some colleagues were presenting findings on their large study into abortion stigma. And what they realised was that to get to the heart of things like abortion stigma, to try and have people conceptualise reproductive rights as human rights, they were saying, well, you have to unpick how people come to hold certain views. And what they realised was that even amongst health professionals, doctors, midwives, there were some quite insidious views around reproductive rights. So what that study realised was that you had to go and look at medical students who were in university. You had to look at what they were being taught about abortion, about reproductive rights, because obviously if you wanted to change attitudes, you had to do it there. So again, perhaps mirroring some of the things that Rebecca and Emily have already touched on, I was interested in the fact that, well, we are teaching the lawyers of tomorrow. If we want lawyers to understand and conceptualise things like reproductive rights or other women's issues as human rights, then I wanted to find out, well, what were they actually being taught in the classroom, and what were some of the views and the attitudes around this? So that was really the sort of the impetus for the pilot study. Again, a small caveat, these are only the preliminary findings. So I've done a sort of first level kind of coding and analysis. I obviously need to sort of finish off doing this, so I don't have the sort of amazing statistics that we've seen on some of the previous slides, but I wanted to just give like an overview and a flavour of some of the key themes that have started to emerge from this study. So one of the issues that came up, I think this came up in every interview, and for a lot of the respondents, this was a core central issue that emerged from the research, was the lack of engagement from male students, and just how much this sort of weighed on their mind when it came to discussing women's rights in a human rights module. Often when I spoke to a lot of academics, again, perhaps thinking what we've just been talking there about with Vidya and thinking about human rights textbooks or international law textbooks, if you look at a human rights textbook, what you will often find is that there is one chapter usually badged as women's rights, or often sometimes even women and children badged together. So often that's how it's taught in a human rights module. And perhaps some of the respondents realised that in doing that, they are perhaps inadvertently gendering the content by saying, well, if this is Women's Rights Week, then presumably every other week we are not looking at women's rights. Are we looking at male rights? And there was an acknowledgement that in doing so, you tended to lose engagement from male students, who obviously just considered that, well, if this was 1 week, if it was one set of content, then perhaps it wasn't relevant to them. So just to give you a sort of slight flavour of some of the things that that came up in the interviews. So one of the participants, they said, I remember in the module that I taught where we had a section specifically labelled Feminist Perspectives on Women's Rights. There was a group of lads who had a lecture in the lecture theatre before I gave that lecture, and they walked out as I walked in, and I was like, where are you going? And they just said, it's all women's stuff this week, isn't it? We don't really think there was much we could add, and off they went. Similarly, another participant said to me, they said, I can see the glazing over on a lot of the boys, certainly the younger ones. There's a sense that this doesn't concern me. And very often, when the women's rights workshop is coming up, you tend to get more of the female students turning up than you do the male students. And I've had it where none of the boys have turned up at all, and I don't think that's coincidental. So there was issues around engagement, and this then fed into this was a motivation for a lot of human rights academics as to, there's often pressure from universities to maintain engagement, to maintain student attendance. So obviously they talked about not wanting to alienate certain students. Another key theme that emerged was around the issues of offence and controversy. This was quite surprising to me because most of the participants that I spoke to self-identified as feminist scholars. Yet they themselves would often use adjectives such as controversial, difficult, provocative when they spoke about the particular issues that they had badged as women's rights. Reproductive rights was considered to be a particularly polarising and controversial issue, and even though many of the respondents I spoke to were keen to integrate this into their human rights modules, there was often a real fear or a real worry that this would be problematic because it was automatically considered controversial. So again, what came up here was the focus on not alienating certain groups of students. That could be male students, it could be students from a religious minority. And for this reason, many of the respondents felt it better than to badge all of their controversial issues or material under the women's rights banner. So often they had 1 week and they said, they would warn the students in advance, they would use content warnings. And if they were going to talk about reproductive rights, if they were going to talk about FGM, forced marriage, they would often badge that together. And of course, that would become the controversial class. So I thought this was really interesting, and it was interesting to talk around some of the fears or just perhaps the overthinking that a lot of the participants had around that. I did speak to a few that talked about how they didn't like the idea of using the headline or the badge women's rights, and they wouldn't have a separate seminar. They would try to mainstream or seed this sort of content throughout the modules. But in doing so, they often talked about how then there was a worry that you were perhaps hiding it, you were perhaps you were perhaps sort of bringing it in under the radar, and therefore there was a worry that students wouldn't actually perceive this material as feminist or as dealing with women's rights or women's issues. Another surprising theme that emerged to me, and I think this is just because it was very different from my own teaching background, where often I was used to quite small modules. I tend to teach a lot of master's modules, or I had previously. So often I had sole control over the entire module. So I wasn't really having to engage very much with colleagues. A lot of the academics I spoke to had a very different approach to teaching at their institution. So those who did what I've referred to as team teaching, or indeed often early career scholars who had inherited a human rights module from someone else that was already on the books at their institution. They talked about there was a reluctance by more senior colleagues to introduce a greater focus on women's rights within human rights modules, or indeed even to utilise the more critical or feminist materials. This was often presented because of a need to focus on core and doctrinal human rights issues and scholarship. And whilst most respondents said that they already utilised critical materials, many responded that they got what they termed pushback from their colleagues, saying that they shouldn't use too much of it. So again, just a flavour, I put a quote here from a respondent who said, "When I took over the module, the reading list did not have a single female author on the list, not a single one," which for a human rights module I just found quite startling, but that's what they said. And again, another respondent said, "I wanted to introduce the students to queer theory a little bit. There was some raised eyebrows about that." So generally this just perception that you could have a little bit of theory, you could talk about feminism, you could talk about women's rights, but not too much. So those were some of the sort of the key themes that emerged from the study. So just to kind of finish up and try and sort of keep on time, as I said, this is sort of at the early stages of coding and analysis, and I do need to write this up and do all these things with it. But for me, some of the key conclusions from this research, for me, one of these things has been around the issue of labelling. And I suppose this feeds into what we've already been talking about today is, how do we badge, how do we tag, and how do we label certain things? Because in using certain labels, we are already, we are bringing emotion, we are bringing our own biases. So I think we really need to think about how we label certain issues in human rights law. I think even though, most of us here are probably quite familiar with, critical scholarship, I think there's probably still a long way to go, in having a sort of broad church, in using more critical and particularly feminist, or whether it's feminist, or whether it's 12 scholarship, or whether it's kind of queer theory, trying to actually get people to embed this in their reading lists. And also, I think just coming back to this idea that's also been mentioned earlier about we need to unpick why we brand certain topics as controversial, because often in doing this, when we're talking about women's rights or women's issues, we are already bringing so much emotion and preconceptions to the table. So that's the sort of early conclusions, and I'll just leave it there. So thank you.
Thank you very much, Lindsay, for this very, very interesting presentation. So I know that it seems that we're running out of time, but we can stay a bit longer. I have been confirmed by the organizers. First of all, again, I want to use the right that I have as a chair. So I'm going to ask you a question, and it's also related to some of the points that were discussed in the previous presentations. But when I hear you about this, I always had the feeling that there are also policy choices within the academic community. So when you decide what is being taught in a course, what readings are being provided, so there is a deliberate policy decision, sometimes is not very explicit, to teach or to decide to teach certain subjects. And I fully agree with you that I think we need more of these decisions to happen in terms of women's rights. Unfortunately, it's not yet the case, but we have to push in that. So what I want to hear from you is this idea of policy decisions from those members of academia, of the academic community. And then I know that Barry has some questions as well.
Yeah, well, first of all, thank you for that presentation. It's so interesting, and it's just so disheartening at the same time, to be honest. Just one thing that came to mind, which you raised in your presentation, was this idea of team teaching, which is something that I'm experiencing for the first time this year. And I just wondered, that's an interesting area which I don't think is talked about that much, actually. The fact that there are these kind of negotiations that have to go on between different instructors. And I just wondered what your experience was of team teaching, and whether you have any strategies that you might be able to share of how you've navigated that in the past. And actually, this maybe just to open it up to everyone a little bit as well, just to put this in conversation. I think one of the issues that we talk about today is also positionality, both the positionality of us as instructors, but also the positionality of our students. And I know this was I think expressly mentioned actually in Rebecca and Emily's presentation, and I just wondered, and this is really for anyone, what I don't know if strategies is the right word, but what methods you found useful for engaging with positionality in the classroom, both as an instructor and of your students? Thank you.
Okay, so yeah, thank you for both of those questions. I'll say first of all, Barry, I don't have a huge experience with team teaching the way that many of the respondents I spoke to had. So as I said, a lot of my human rights teaching experience has been at master's level. I don't know if that, I think that was just simply because when I was doing my PhD, someone at the institution I was at went on maternity leave, and it sort of, I was naturally sort of brought in to cover there, and I just kept doing it. And because the master's modules were quite small, and because they tended to correlate quite well with people's research interest, and they tended to be quite focused, there was a lot less team teaching. So my only experience, I suppose, of doing a kind of team teaching has been when I then finished my PhD and I sort of got my first lectureship. I was the module convener, but obviously this was undergraduate. It was an international human rights module. There was about, I think, 150 students. I was the module leader, but I had additional members of staff who were obviously doing tutorials and workshops. But they were mostly GTAs. So I think for me, my experience was probably quite different from everyone else's, because even though I was kind of quite keen to, you know, have a very informal teaching team, I think just automatically there was a hierarchy there in the fact that, you know, I was a lecturer, they were GTAs or PhD students, I was the module convener, they were sort of doing the tutorials. So I think, you know, I had all the decision-making power when it came to content. And I suppose this is great for me because I got to teach what I want to teach, and I put all of this critical scholarship on the reading list, and I didn't think twice about it. But speaking to many of the respondents who, particularly when they teach at undergraduate level, many of them talked about, you know, they talked about teaching modules where, you know, there were perhaps four members of staff. And they talked about issues around the fact that where there was often a senior member of staff who perhaps did the least amount of teaching, perhaps only did 1 or 2 lectures, but because this was a senior member of staff and because this was a team, you had to negotiate almost by committee to try and update the reading list or to change certain things. So yeah, it was very difficult. It was a very difficult world for me. We did talk about strategies and various things, and again, the responses really seemed to vary. It just really seemed to be whether the people that you work with, whether they use a lot of critical methodologies, whether they're into feminist or post-colonial or queer scholarship, then they tend to be quite respondent to it. People who tend to teach human rights from a very almost public law doctrinal background, they would say that those colleagues were really not interested. And there was often a fear that if you introduced too much critical perspectives, you would somehow get away from the important stuff, the actual law. So I think that was perhaps at the root of some of it. But yeah, maybe some of the other participants and people here, maybe they'll be able to sort of share some advice on how you manage team teaching. Just to probably touch quite quickly, because I know we are sort of still pushed for time, on the other question that Ezekiel put around policy decisions. This was something quite depressingly that came up quite often as well. And this was something, it took the research in a direction that I didn't think it was going to go. One of the things that came up in almost every single interview that really surprised me was the issue around content warnings, which have somehow, I think unwittingly for academics, have somehow become part of Britain's wider culture war at the moment. And it's often used by, you know, certain arms of the right-wing media or the right-wing press. So there was sort of almost a politicization of the idea of content warnings. And a lot of the respondents talked about how they worried about including too much of the controversial material in their module, because then they felt like they were they felt like they were almost damned if they did and damned if they didn't, because in including controversial material, there was often then a thought that they should use a content warning, but some of them talked about how there were discussions at certain institutions and diktats from, or policies from senior managers that said that they should avoid content warnings, because whether that was political views on content warnings, I don't know. I got into it with some of the respondents, but others just said that, if something needed a content warning, that for them was almost enough to consider not putting it in their module, which I found quite fascinating, because my entire modules can probably be badged as controversial, so maybe I just get round it that way. And I think it was Rebecca who mentioned earlier, if you make the content available to the students before they sign up, then perhaps this is easier as well. But when you talked about policy decision making as equal, that was one of the things that really struck me, was there was very much a difference between academics who felt that they had the support and they had academic freedom from senior management or their institution to do what they wanted. And then others, I think, had a really different perspective, where there was very much, not that they had to have their modules approved, but there was very much an oversight of what content they wanted to teach. And if they were going to teach things that were considered controversial, they perhaps, they just wanted to make sure that they had support for this, which I just found to be fascinating. And I didn't think that was the sort of stuff that would come up at all. So hopefully that answered your question.
Yes, it does, actually. I think it's fascinating. I know Vidya has a comment to make, and we don't have a lot of time, so just to be aware of this.
Hi, sorry. No, I was just going to respond to Barry's question about teaching teams and how we think about them. And I think some of the comments that Lindsay has made already address the point of the fact that inherent in teaching teams can be hierarchies which are reproduced by universities. So in terms of seniority and also in terms of demographics, you can get the same kind of hierarchy. So it's being attentive to that, which is required and in a teaching team, and also being able to feel that you can express that these hierarchies are being reproduced in ways which are adverse to learning and education. And I think Rebecca and Emily's presentation on the effective aspects of teaching plays in here, in terms of just the emotional intelligence you need to be able to read who in your teaching team is comfortable doing what, and with the allocation of teaching topics. But the other thing I was going to say about teaching teams is that on the one hand, they also foreground or spotlight different styles of teaching. And if they're handled correctly, especially when students are introduced to a teaching team, to say, here are 4 or 5 different pedagogical ways to teach international law, meaning not I'm the module leader and I'm going to teach it this way, and then you judge whether everyone else conforms to the way I teach. I think that is such a really important thing to recognize and to say, is to set the tone of saying that there's different ways of learning, and students learn differently. So some students will just like different kind of methods of teaching, and so exposing them to that diversity is really important. Thank you. Sorry, just wanted a brief comment.
Thank you, Dia. And Rebecca has also a point.
Yes, thank you, Ezekiel. Just very briefly, following on those comments, I just wanted to add one strategy I found useful in the classroom is when I was setting the tone for how we would deal with emotions. I started off by following positive psychology movements and this project called the Positivity Project. And we first taught students their character strengths. So they had to set off alarms on their phone to go off at various times of day. They would look at the activity they were doing, if they got energy from it, if they were good at it, if it drained them, if they enjoyed it. And through that, we actually worked through a matrix of things like courage, humor, transcendence, humility, frugal, different traits. And students learn their own profile at the beginning. And that immediately changed the conversations from emotions are something we need to suppress or dodge or downplay, to saying, actually, there's something great. If we could learn more about our own emotions and be more self-aware, then we can also be more generous and more curious about thinking about the hard stuff like my own identity as a cisgendered middle-class white woman at a privileged university, right? And so it was a way of, I think the order of things matters, and sort of building blocks and leading students kind of to water, and then they drink and they blow it all up. They taught me more than I taught them in a way. So I'll just put that there. I can share links on those resources.
That'd be great, Rebecca. Yes, please. I mean, and this goes for all the panelists. If you have links or papers or information that you would like to share with the audience, please feel free to do so. Having said that, I don't think there are any further comments or questions. I'm going to give the floor to Jean-Pierre, but before doing that, I'd like to thank you all for this great presentation. I think they were very interesting, and I also like to thank the audience for the questions that they have asked. I hope that we can continue these discussions because they are very much insightful, and yes, thank you very much. Jean-Pierre?
Thank you very much. And I don't have much to say except to once again thank all of you for your excellent presentations today. It's been absolutely inspiring. Thank you very much, Ezekiel, for your chairing. And just to remind everyone that we will be back at 1:30 for the next session, which will be about the international law teacher. So that's in about 34 minutes or so. Again, thank you very much and have a lovely afternoon.
Thank you so much, everyone. Thank you.